I would like to start out by saying that although I went over time, it was only by a few seconds since I did introduce myself in the beginning and time does not start until I begin the actual speech. Also in the rules, there is a small margin allowed to go over or under time, so therefore it is not a violation or bad mentality because I was taught it was not strictly 5 minutes. Education is not violated here because it is not ruining learning by going over by a few seconds because I was just finishing my sentence and it didn't cause any harm. If there was to be a forfeit due to time violation, it would have to be for the AF because she knew and argued that there was a time violation yet still continued to do so in her own speech. But for the sake of the debate, I think that it is fair we just move past it since we are now on equal terms. Next, just because the AF defined the resolution as talking strictly about internet revenge porn doesn't mean that we have to go with it. In this mindset, the AF could make the debate based on just the topic they want to discuss and they can win, and there's no rule stating that you can do that. Therefore, talking only about revenge porn and only revenge porn on the internet is a violation of the resolution because although revenge porn is a significant topic, it is not the only significant topic when discussing internet pornography, and it does not only occur on the internet. Also, it is only in the AF's opinion that focusing on this would lead to a more focused and educational debate, and this cannot be backed up. Next, just because I didn't state all the ways that revenge porn violates states' rights does not mean that we should just drop the case because violation of rights is a large enough reason to not vote for the AF. By stating that I did not list all the ways that there are violations of state rights shows that there are more than what I did state, which shows that the AF agrees at this point that there are many violations of rights in their plan. Also, violation of First Amendment rights in any way is reason enough not to vote for the AF, especially since she is using the example of Holly Jacobs, who did take some of the pictures herself, which she stated in CNN News. Since in the citations, the AF did not give enough information to find the article she cited, stating that Jacobs didn't consent, I found a CNN article from the same date where she is quoted stating that she took some of the pictures, and we should therefore go by this. The Supreme Court does ultimately decide which bills are passed, and in my last speech I stated how the judge explained why the bills wouldn't be passed, not that they voted on such plans. The Supreme Court will not vote on a plan such as the one stated by the AF because they are often too broad and the law needs to be clear and narrow to be able to pass, otherwise it infringes on First Amendment rights of free speech, and the AF's plan does not take enough care in thinking of ways to prohibit free speech in a way that only takes it away when infringing on others' rights, so therefore their plan will not pass by the Supreme Court and should not be voted on by you, Judge. Also, I did not say that we should give up on looking for website owners, but that this plan cannot be enforced on website owners because they have protection to prevent them from being liable for content generated by these users. For example, the AF is saying that the owners post these pics themselves, but in most cases the owner has no part, but the users of the site are the ones posting the content. Also, as stated, owners cannot take pictures offline unless they are copyrighted because it will infringe on First Amendment rights, which I stated, but was ignored and dropped by the AF. Also, I didn't say that I wanted them to keep doing this, but that it was hard to stop them, and the plan put forth by the AF would not help this problem because they have no way of tracking IP addresses, which is the main problem in internet pornography, which the AF's plan has no way to deal with. Also, as I previously stated, Holly Jacobs did consent, which was quoted and published by many websites, including CNN. She said that she consented to the pictures and took them, just not all of them, so therefore the AF is taking the quote and using it out of context, which is unfair and incorrect, and you should not vote for them on that. Also, saying that humans make errors is not enough reason to protect victims like Jacobs and pass this law because the individuals make one mistake by posting these pictures, but they're the ones who are going to be punished. That doesn't seem fair on account that, in this case, Jacobs did consent. And in the case of Tyler, stating that revenge porn will cause people to commit suicide is untrue because suicide cannot be proven to be caused by just this one thing, and there could be other problems in an individual's life which leads up to it and therefore cannot be a true harm. To conclude, there should be no violation of time or education by myself because the AF also went over time. The AF assumed that the resolution could just be about internet revenge porn, which is a violation because the AF cannot just decide what they want to argue and say that everything else is off limits because that is unfair and a disadvantage. The AF's plan for regulation denies the victim's guilt for initially giving consent to the pictures. Giving consent and giving pictures means that these pictures now belong to the individual who they were given to, such as the ex-boyfriend in Jacob's case. They are now their property and they can do as they please with them, and trying to stop sites from putting them up would be infringing on First Amendment rights. Also, even if you try to stop sites, this plan proposes no way to try to find the owners and deal with IP coding problems or how to get past protections that sites have to prevent them from getting in trouble. Also, although harms are present in revenge porn, their harms of the plan presented are much greater and the plan should not be voted on, Judge. Also, I just would like to state that my last speech is no longer available on here and I don't know why, but I'm going to put the link for it on YouTube in the citations and I just want to say that. Thank you.